Good evening, everyone. I, Saquib Rahman, Senior Lecturer at the Department of Law, North South University, would like to welcome you all to our webinar today. It would be a pleasure on our part to be able to listen to Professor Trachtman, who has very kindly made the time to talk on a very interesting issue, international law, carbon reduction, and carbon border estimates. Before we request Professor Trachtman to start, I would like to bring to the notice of the listeners that the chat box is open and that they may address any questions there in the box. The audience is requested to please keep their microphones off at all times. And lastly, I would like to extend my thanks on behalf of the Department of Law to all of you present here. Now, regarding our guest speaker, Joel Trachtman is Henry J. Breaker, Professor of Law at the Fletcher School of Tufts University. He graduated in 1980 from Harvard Law School, where he served as editor-in-chief of the Harvard International Law Journal and practiced in New York and Hong Kong for 9 years prior to entering academia. Professor Trachtman has served as a member of the boards of the American Journal of International Law, the European Journal of International Law, the Journal of International Economic Law, the Cambridge Review of International Affairs, and the Singapore Yearbook of International Law. He has consulted for a number of governments and international organizations, including the United Nations, the World Bank, and the OECD. From 1998 to 2001, he was academic dean of the Fletcher School, and during 2000 and 2001, he served dean at interim. He has been a visiting professor at Basel, Hamburg, Harvard, and Hong Kong. Professor Trachtman is the author of several books on international law that were published from Cambridge, Oxford, Harvard, and other acclaimed publishers. But before we listen to Professor Trachtman, I would like to request Professor Rizwanul Islam, Chair of the Department of Law at North South University, for his introductory remarks.
Thank you, Saquib. Good afternoon, Professor Trachtman. Good morning, good afternoon, or good evening, dear audience, depending on wherever you may be. Carbon trading or response to global warming is a very pressing issue, not just for Bangladesh, maybe for many countries across the world. All of us are witnessing the threat that climate change can pose to our future. Maybe it's not a question of the future even. Maybe we are seeing what is happening in some parts of Europe or what is happening in the Louisiana just a couple of days ago or in other parts of the world. Now, how do we respond to this threat? One way would be to put some sort of restriction on some goods which either are carbon intensive in terms of production or in terms of use or in other ways. But if states try to do it, about 160 odd states are, or if not states, customs territories are parties to the WTO. And their domestic freedom to put in place fiscal rules are constrained by the WTO rules. Professor Trachtman is a leading scholar in this area. He has written some wonderful things on this area, and I have had the pleasure of reading one of his recent articles on this topic, on which he has very meticulously dealt with Article 1, Article 2, and Article 3 of the GATT, and also with Article 20 of the GATT, not just through the cases that would shed some light in the WTO era, but also the GATT working parties practice and the GATT reports. And he has very eloquently tried to project that if there is some sort of carbon restrictions or carbon credit mechanism, how can that play out in the WTO regime? Not only that, he has also projected, as many of you would know, that the WTO dispute settlement mechanism works in a way that there is ample scope to, what some scholars say, to go on with an efficient breach, that there is a policy or law made by a state which may perhaps be incompatible with the WTO rules, subsequently found to be so by the WTO dispute settlement body. But in the interim, that law can go on for at least 3 years or so as the WTO dispute settlement process is exhausted. So, what would happen if that sort of a scenario exists? So, all these are questions that I think somehow you address, and I'm sure it will be a very interesting talk. I look forward to Professor Trachtman's talk and also to your questions here. Thank you all for your time.
Thank you very much, Professor. Professor Trachtman, please start whenever you're comfortable. Professor, you might want to turn on.
There we are. Okay. Thank you very much, Professor Islam and Professor Rahman. It's an honor to be with you and to speak with North-South University about this critical topic. And it's a topic that I think is central to the future of the planet. And as Professor Islam has said, central to the future of Bangladesh in connection with the need to reduce global warming, to halt climate change, to halt the growth of climate change. And the way I think it's useful to understand this issue from an overall perspective is as one relating to the growth of international law and the ability of global society to respond effectively to its public policy needs, its need to reduce global warming. And part of that problem is arises from the fact of the structure of the international legal system. The fact that the international legal system is in some ways primitive in its legislative capacity, in its ability to make new rules. And perhaps part of that primitive aspect of the international legal system is this phenomenon that international lawyers have been discussing for 20 or 30 years, the phenomenon of fragmentation. The idea that we make international law under the trade heading and under the environmental heading and under the finance heading and under the human rights heading, and we don't really integrate the different subjects of international law very effectively. And so this fragmentation is part of this primitive aspect of international law, and it really prevents us, it limits our ability to achieve multiple social goals at once. So in Bangladesh, as in my country, in the United States, you have a single legislator that's able to balance trade and environmental protection, commerce and regulation. In the international system, we have a very sloppy, a very imprecise, a very inadequate way of dealing with that. So we have two clear social goals. One, the social goal that seems less important at this particular moment, but it's still quite important, and that is the benefit of free trade. And the WTO has grown from bilateral trade agreements in the late 19th century and early 20th century to the General Agreement on Tariffs and Trade, which began after the Second World War in 1947, to the World Trade Organization, which is in some ways the successor organization to all of that in 1995. And it's a binding international agreement with 164 member states and a binding system of dispute settlement. So you might say that the WTO legal system focuses on free trade and is relatively binding and firm. And it focuses on the social goal of free trade. But we have another social goal that is very pressing, and I would say today more important than free trade per se, and that is the goal of avoiding climate change catastrophe. And here we know that different states will experience climate change differently. Some states may benefit from climate change. Other states like Bangladesh may be at great risk from climate change. So the detriments of climate change are distributed unevenly. But also different states use fossil fuels and other and engage in other activities that cause climate change to different degrees. And the United States, my country, is one of the largest users per capita of fossil fuels, and it's even more if you begin to count the fossil fuels used in producing goods for the United States. So China is the largest producer of carbon, but a lot of China's production is in manufacturing for other countries, and the United States is the leading market for Chinese products. So we have these two different social goals and this problem, as I say, of fragmentation of firmer international law for trade, for promoting free trade, and in some ways weaker international law for addressing climate change. So just to be very clear on the primitive nature of the system is one of treaty-made international law. Customary international law is not as important in either the environmental setting, certainly not in the global warming setting, and it's not very important either in the trade law setting. So we're focusing on treaties. And of course, only countries that accept a treaty obligation are bound by those treaty obligations. And in the WTO, as I've mentioned, we have binding language that is mandatory. We have mandatory dispute settlement since 1995, although the United States defection from the appellate body, the United States scofflaw aspect in avoiding the appointment of new appellate body members at the WTO has made WTO law less binding. And then a possibility for rebalancing for violation when a violation is found. So that's the WTO legal system. And then the principal global warming law is contained in the Paris Agreement under the Framework Convention on Climate Change. And that has 191 countries, but it contains much softer, much less specific obligations. And the main relevant obligation is to declare a unilateral, nationally determined contribution, nationally determined reduction of carbon, but it's a soft obligation. There is no adjudication, no penalties for violation. And also, and this is a separate feature, but one that is important to our discussion, the Paris Agreement is informed by the idea, which makes perfect sense in some ways, but is inappropriate in other ways, that there should be so-called common but differentiated responsibilities. So large users of carbon, like the United States, should reduce their carbon use to a greater extent than smaller users of carbon, like Bangladesh. So that idea of common but differentiated responsibilities suggests that there should be greater carbon reduction by the countries that are wealthier and that use more carbon. So what do we need to avoid catastrophe or to reduce the scope of catastrophe? First, we need binding carbon reductions, binding at least in the sense that they're effective in causing states to reduce the carbon emissions of their producers and consumers. And so we need effective carbon reductions that will limit global warming to more acceptable levels. And second, and this is inconsistent with the idea of common but differentiated responsibilities, we actually need a globally homogeneous carbon price, a uniform carbon price, to avoid what's called in this area leakage. And leakage is the idea that if the European Union, for example, establishes a carbon price internally, it may be that producers move their operations from the European Union to other countries that have lower carbon prices, like perhaps Bangladesh or China. And so there's disinvestment from the European Union. And the European Union wants to avoid that. And they want to avoid the loss of trade opportunities that would come from more costly production in the European Union because of carbon pricing, because of the cost of carbon. So leakage is the loss of investment and trade by a country that regulates. And by the way, one of the important things about leakage is that it results in undermining the carbon reduction policy. So if the European Union sets a carbon price to try to reduce global warming and people move their operations to China, then they really haven't effectively reduced global warming. So we need an international treaty that sets up a uniform global price for carbon. And there may be ways to adjust that so that it's less burdensome for poor countries, that there's less responsibility for countries that have done less to cause global warming. This is the climate finance question, which is also very important. If we had an international treaty that did this, that set a global carbon price and that was binding, we would need to make sure that we specified that those obligations were effective, and we wouldn't really need to worry about WTO law as long as those obligations were otherwise effective. But then we have the question, how do we make that carbon treaty effective? How do we make obligations to reduce carbon effective? And one idea promoted by the Nobel Prize winning economist at Yale, William Nordhaus, is to have trade penalties. He speaks about what he calls climate clubs, where groups of countries would impose trade restrictions on countries that don't reduce carbon. And this would definitely raise the kinds of WTO law issues that Professor Islam spoke of. It would raise issues under WTO law to impose trade restrictions on other countries. So the question would be whether your climate obligations would be something that would override your WTO law obligations. And this is an element of the primitive nature of the international legal system, in that the international legal system does not provide effective answers to those kinds of conflicts between different kinds of treaty obligations. So we don't have that kind of treaty that I've just described. And so countries or groups of countries like the European Union are beginning to respond with unilateral action. And the European Union proposed in July a border carbon adjustment mechanism. And the idea for the European Union is to say, look, here in the European Union, we have a system of carbon pricing, of carbon trading the ETS, and we're going to just ensure that when goods are produced in the United States or China or Bangladesh, when they come to the European Union, that they pay a similar price. It's a response to this phenomenon of leakage. And it's a unilateral action to reduce, not to totally prevent, the shifts in investment and the shifts in trade that would come from a domestic unilateral carbon price. And the reason it's not complete is that the European Union is still competing in export markets with those Chinese or United States or Bangladeshi goods that presumably haven't paid as high a carbon price. So the European Union is still at a competitive disadvantage, but this reduces that competitive disadvantage. So as I've said, the ideal approach is a single global carbon price. The real circumstance is this unilateral action by individual countries to establish domestic cap and trade or carbon tax regimes, and then trying to address leakage through border carbon adjustments. And just as a footnote, I'll say that those border carbon adjustments would mean tariffs on imported goods from other countries that haven't set as high a carbon price. But it would also mean possibly reducing the payment of the carbon price for exported goods to address this problem that I mentioned of export competitiveness. And there's a recognition here by the European Union and by other states that are considering greater action, that it would be inappropriate to double regulate or double tax carbon. So it's necessary for these unilateral national regimes to recognize carbon prices that are paid abroad, or the low level of carbon used in actual production by some factories abroad. So the idea would be to adjust the border carbon adjustment for actual carbon used in foreign production, or for the carbon costs already imposed by the exporting country. And this, in a sense, is interesting because it raises all sorts of World Trade Organization, of WTO law issues, and it requires a kind of extraterritoriality in which, for example, the European Union, if it imposes these border carbon adjustments, looks into production at the United States and says, we're going to charge our border carbon adjustment by reference to either the United States regulatory system or the actual use of carbon in production in the United States, or really both. And we're going to have to look at that. We're going to have to audit the use of carbon. We're going to have to charge for it. And what we're really doing is reaching out and telling people in the United States or in China or in Bangladesh or in Canada how much carbon they can use if they want to export to the European Union. And this is where we get into some issues under WTO law. As Professor Islam has said, we have the question of discrimination, and two types of discrimination. One is discriminating among different countries. This is most favored nation discrimination. So if, for example, Japan has a good carbon regime and the United States has a weak carbon regime, the European Union would be charging a carbon border adjustment on United States goods, but perhaps not on Japanese goods. Here, the United States might say that's discriminatory. The question is, what is the definition of discrimination? Because the European Union would respond and say, we're not really discriminating, we're just focusing on the level of carbon used. And so this puts pressure on the question of the definition of discrimination. I'll come back to that. So that's the most favored nation, country to country discrimination question. That there's a national treatment discrimination question. Here, the United States or China might argue that you're charging a border carbon adjustment for United States goods, but you're not charging that for goods produced in the European Union. And here, one of the questions, and it's the same question about most favored nation discrimination, is, are you permitted as the importing country to distinguish between goods on the basis of the production process that was used to make them? Or are you only permitted in your regulation under WTO law, under Article 1, most favored nation treatment, or under Article 3, national treatment, are you only permitted to examine the goods themselves? And so this is really a question that relates to some of the earlier jurisprudence in the WTO and even in the GATT. And that jurisprudence suggests today that when you regulate, you're only permitted to regulate with respect to things that affect competition. And the things that affect competition generally are things that consumers are concerned about. And here, one thing that is unfortunate but true is consumers just want a low price. They don't care so much. They don't care so much. Some care more than others, but they don't care enough about how much carbon was used in producing the goods. So the European Union has proposed a carbon border adjustment mechanism regime. It raises significant questions of discrimination. It raises a related question of whether it's charging an additional tariff, which, as you may know, the GATT and WTO system was designed to reduce tariffs over time, and countries bind their tariffs. So depending on whether you see the carbon border adjustment tax as a kind of tariff, you might say it's an additional tariff. But the fundamental question is really one of discrimination. And then here, it's important to say that even if the European Union's carbon border adjustment mechanism, or a future United States one or a Canadian one, distinguishes in this way, and even if it violates Article 1 or Article 3 of GATT or these Article 2 tariff restrictions, it could be accepted under the general exceptions of the WTO GATT treaty. And the leading general exception to think about is Article 20, paragraph G, which specifies that if your measure is to conserve exhaustible natural resources, and here the climate would have to be understood as a natural resource, which is a question itself. If you're conserving exhaustible natural resources, and if you make your restrictions on imports effective in conjunction with domestic regulation, in other words, if you're even-handed in your approach, then that would permit you to have an exception. And the core requirement here is even-handedness. You would have to treat different countries alike. And so that's a question about the European Union's carbon border adjustment mechanism. Here, the European Union's draft has said that the European Commission might conclude recognition agreements with other countries that have similar regimes. one question is that itself discriminatory? I think it would be reasonable to argue that a recognition arrangement that is simply based on how much you regulate carbon would not be discriminatory. One issue that has come up is that the European Union provides free allowances for certain industries inside the European Union. They would have to do the same for imported goods. They couldn't treat imported goods worse than they treat domestic goods. This is the structure of the European Union system. There's also this question that I mentioned of how to audit or verify carbon use abroad. And the proposal from the European Union says that where actual emissions cannot be verified, default values would be used. Here, the European Union will have to be careful to make sure that it is open to different methods of verification and that it is really honest in its permission for different methods of verification to be used so that it's available to other countries to have their actual emissions used rather than these kind of punitive default values. The default values are specified to be set at a level corresponding to the emissions of the 10% worst performing sites in the European Union. So it's a punitive kind of arrangement. Now, I will say that verification is technically very difficult because you have to figure out on a plant by plant, on a factory by factory basis, how much fossil fuel or other greenhouse gases are being used. And so you have to allocate fossil fuel or energy costs to specific products, and different producers might be more or less difficult to audit for this. Where you have long value chains, complex production, it also raises difficulty in auditing. So it's going to be difficult. Countries like China and the United States have already responded. The United States global climate change representative John Kerry has said that the European Union's proposal has, quote, serious implications for economies and for relationships and trade. And he argued that the carbon border adjustment mechanism should be considered only as an option of last resort if all other options for reaching solutions for global decarbonization fail. Well, we're kind of at that point, but maybe there's a possibility for that global effective treaty that I mentioned at the outset that would avoid the need for carbon border adjustments. The United States, in its proposals for domestic carbon pricing in recent years, has considered carbon border adjustments itself. The US Secretary of the Treasury, Janet Yellen, has said that countries that introduce carbon border adjustments could form carbon customs unions compliant with WTO rules. That raises lots of interesting questions. So there could be cooperation, but there could also be trade wars based on these carbon reductions. And one question that I think is important to Bangladesh, maybe to China as well, is how will developing countries be treated? How will these common but differentiated responsibilities be reflected? And here I'll just repeat, the idea of the carbon border adjustment mechanism has a certain extraterritoriality to it, a certain coercive impact on states like Bangladesh or China, saying, well, even if you don't regulate yourself, we're going to regulate when your products come into our country. And a number of countries, a number of developing countries have expressed grave concerns about this European Union proposal. there is this sense of inconsistency with the common but differentiated responsibilities aspect of the Paris Agreement. This is a fragmentation issue itself. You might say that that inconsistency renders the proposed European Union carbon border adjustment mechanism arbitrary and unjustifiable as a type of discrimination, making the availability of the Article 20 exception in GATT questionable. So there are all sorts of difficult questions, and I think the main guidance to the European Union would be to try to be as even-handed as possible and to reflect as carefully as possible the needs of developing countries and this common but differentiated responsibility idea. Even if the European Union exempted developing countries, that also could jeopardize the Article 20 exceptions under what we call the chapeau of Article 20, because there might not be sufficient justification for that differential treatment based on underlying conditions. I should say that the European Union Parliament has said that any carbon border adjustment mechanism should provide special treatment for least developed countries. And it may be that the European Union tries to address this through its generalized system of preferences. Well, if this comes to fruition and if parties fight about it, it could come to WTO dispute settlement. As I mentioned, the WTO appellate body is still not functioning because the Trump administration and now the Biden administration have failed to cooperate in appointing appellate body judges. So maybe the dispute settlement system will not be able to address this issue, but if the dispute settlement system is revived, it's possible that it would be useful to police the non-discriminatory nature of these carbon border adjustment mechanism. But you can see there are lots of judgmental questions that haven't really been addressed by political branches, by treaty negotiators. And it puts a big burden on judges to try to solve these problems. So in my mind, there's a need for a political solution. But that consensus rule in our primitive system of international lawmaking makes that very difficult. So the question is, could we come up with a more efficient method of making rules in this area, perhaps through some kind of plurilateral system, perhaps through some kind of linkage, the way William Nordhaus recommended in his climate clubs work. Could unilateral action be a basis for coming to multilateral agreement? So how can the international governance system adapt to address these issues? So let me stop there and open up to discussion and questions, if you will.
Thank you very much, Professor. Professor, we do have many questions. And I would like to convey each one of them to you whenever you're ready, Professor. Professor, should I be conveying the questions?
Sure. If you tell me the questions, I'll try to answer them.
Of course. First question, Professor. Would you say that the WTO law is sophisticated enough to distinguish between green subsidy and protectionist ones?
So green subsidies are subsidies, and WTO law allows importing states to apply countervailing duties with respect to those subsidies, provided that they're specific, and some types of green subsidies might not be specific. So that does raise an issue. And it may be possible to address that in future negotiations. But today, WTO law is not sophisticated enough to distinguish between green subsidies and non-green subsidies. WTO law is more sophisticated with respect to import restrictions or import taxes. And here we have the question of discrimination and then the question of whether these exceptions are available. And I should say that the exceptions in Article 20 in a way are a way of resolving this fragmentation, saying that trade law doesn't address good faith, even-handed environmental regulation. I think that's the right way to interpret Article 20. And so as long as you don't use your environmental regulation as a pretext for protectionism, so-called green protectionism, it should be acceptable under those exceptions. So I think WTO law is a bit more sophisticated there, but as the question suggests, these are extremely complex, nuanced public policy questions. And it's possible that judges would either make a public policy mistake, or we as lawyers and judges as lawyers may feel constrained by the text of the agreements or by the jurisprudence that already exists. And so it's possible that a purely legal interpretative solution is not the best public policy solution. And this is why I suggest that some kind of political solution, some kind of environmental-based treaty, or it could take place inside the WTO too, would be useful. I'll just mention one other thing in connection with subsidies, and that is that one of the things that the United States and other countries subsidize flagrantly is fossil fuel production. And we in the United States have direct subsidies for our oil producers, but we also might understand the failure to regulate carbon as an implicit subsidy on carbon. And so in that sense, you might say that WTO law is insufficiently sophisticated to really address fossil fuel subsidies. And here, I think the formal law is not useful in this area. And I would suggest that it be considered whether WTO law could be amended to address fossil fuel subsidies more extensively. The way it's proposed today to be amended to address fisheries subsidies, which are also environmentally unsound subsidies. Thank you.
Thank you very much, Professor. Our next question. Is it not fair to say that trade versus environment is a false dichotomy?
Which is the false dichotomy? Would you just repeat the question?
Yes. Is it not fair to say that the trade versus environment is a false dichotomy?
Well, so I think the way it's a true dichotomy is that we have the market, and trade is the market. And then we sometimes regulate the market, and that's inconsistent with laissez-faire, with the free market. And the environment involves all sorts of market failures, externalities, collective action problems, asymmetric information between consumers and producers. And so there is definitely, and we can see this clearly in the carbon area, there is a role for regulation. And that role for regulation is inconsistent with the operation of the market. It's correcting the market. It's correcting a market failure. That's the economic theory of regulation in this context. And so in that sense, I think there is a dichotomy between trade as the free market and environmental protection as regulation.
Thank you very much, Professor. Now a third question. How would you evaluate the Article 20 jurisprudence developed so far in relation to protecting the environment and other non-trade issues?
So I think that so far, under Article 20, we have not had a disastrous case. And every case in which a national environmental policy has been found not to satisfy the requirements of Article 20, there has been a good reason for that. And when I say a good reason, what I mean is that there was something discriminatory or something disproportionate about the national regulation. And so the examples we think about, for example, are the United States restrictions on imports of shrimp that was fished in a way that was unsafe for sea turtles, the so-called turtles case. And in that case, the United States lost, but the United States was engaging in some regulation that treated imports from different countries differently. And so you might say there it was not even-handed. In the area of China's environmentally motivated regulation of rare earths minerals, also, China was not even-handed in its restrictions on use of rare earths minerals. And so there too, it was appropriate to make a finding of violation. And then in a case where I actually think there could have been a finding of violation, but there was not, Brazil imposed restrictions on imports of retreaded tires in order to protect the Brazilian environment. And even though its measure really was in some ways disproportionate and discriminatory, the WTO appellate body protected its measure. So far, Article 20 has been sufficient to permit good faith, non-discriminatory, proportionate environmental regulation. We have a different outcome, I would say, in the in this other WTO treaty, the Technical Barriers to Trade Agreement, which doesn't benefit from the exceptions in Article 20, and where the United States lost a case relating to tuna labeling, labeling of tuna products as being safe or unsafe for dolphins, where the United States, I think, was reasonably even-handed, but the WTO appellate body found that the United States measure was disproportionate. And so there, I would have argued that the United States should have benefited from Article 20. It should have been found to not be discriminating under the Technical Barriers to Trade Agreement, but the WTO appellate body was more intrusive than I think was appropriate. So the main point is that we haven't had a serious problem yet under Article 20 of GATT, but it's possible that we will. And I think the carbon border adjustment mechanism case, if it comes to the WTO, could raise some issues, especially, as I mentioned, if the states try to, if the states that impose these carbon border adjustment mechanisms try to accept developing countries or least developed countries or provide special and differential treatment to those developing countries, that may raise some difficult issues. So I think it will be a test. Knowing the kinds of people who have served as WTO appellate body judges, my guess is that they would find a way to affirm a truly non-discriminatory, good faith carbon border adjustment mechanism, but it's uncertain whether they would be able to.
Thank you very much, Professor. Here's the next question. From the point of view of the WTO law, would a flat domestic carbon tax be a better option than any carbon tariff on imports?
So I think I'm not sure what the questioner means by a flat domestic carbon tax. One of the proposals that we've seen, which may be what the questioner is describing, and you can follow up if you wish, is to simply have a tax on goods that are generally carbon intensive, like cement or steel, other types of carbon intensive goods. And to have, in that sense, a flat tax and say, we're going to tax those goods that are normally carbon intensive. There, the problem is you set up an incentive problem where it doesn't make sense for producers to reduce their actual carbon utilization because they pay the same price anyway. And so, in a sense, it would be better under WTO law, but worse from a global public policy perspective to have that type of flat tax on carbon-intensive products.
Thank you very much, Professor. Here's the next question. How may a subsidy for reducing carbon use in the production use play out concerning the subsidies and countervailing measures agreement?
It's a very interesting question. And so the way that subsidies law at the WTO works, as I suggested earlier, is that importing countries can countervail foreign domestic subsidies. And there's no real exception for environmental subsidies in that way. And so, for countries like the United States that consume a lot of the goods that they produce, you can still have an effective subsidy for reducing carbon. And if that subsidy is countervailed upon exportation, so be it. By the way, those countervailing duties are only permitted if the subsidy is specific. And so one question that question raises is, could the carbon reduction subsidy be designed so as to be across industries in a way that it is not specific and therefore not countervailable under WTO law? Similarly, it would be useful if countries could get together and say, this is important as a part of the transition to a carbon-free or carbon-reduced economy. Let's accept from countervailing duties these kinds of carbon reduction subsidies. In cases where carbon reduction subsidies have been successfully challenged as illegal, those cases have involved discrimination. So we have a case relating to Canada where there's discrimination in the availability of the subsidy. So I think that it's a good question. Those countervailing duties are a problem, but maybe not the most significant problem for policies that would include subsidies for carbon reduction.
Thank you very much, Professor. We have a question from Dr. Nabil. He says, carbon border adjustment tax using default production facility carbon footprint is still not fundamentally sound in taking care of leakages. As an example, for textile products, it can come one of our best factories, but it will be charged the same tariff whether that product goes by ship or by air. But the embedded carbon footprint is the same. So how exactly is it tackling trade-related carbon leakage?
Would you repeat the question, please?
Yes, yes, Professor. He writes, carbon border adjustment tax using default production facility carbon footprint is still not fundamentally sound in taking care of leakages. As an example, for textile product, it can come from one of our best factories, but it will be charged the same tariff whether that product goes by ship or by air, but the embedded carbon footprint is not the same. So how exactly is it tackling trade-related carbon leakage?
I see two components of that question. It's a very interesting question. One is, I think it's absolutely correct that a default value does not successfully tackle leakage because it treats low carbon factories the same way that it treats high carbon factories. So it's important to use actual carbon. And then the second part of the question is ship versus air. I assume the assumption is that the air travel uses more carbon than the ship travel. And there, I agree that the full carbon cost of the consumption of the good should be charged in connection with that good in order to ensure that consumers and because the consumers are bearing the cost, producers are bearing the cost, are experiencing the full social cost of the carbon. That's the goal of these systems, to make sure that the social cost of the global warming is being experienced by the consumer and then by the producer, so that they reduce carbon accordingly. And you can look at it two different ways. You can say we need to reduce net carbon to zero, and so we're going to come up with a cost that will have that result. Or you can just say, here's the cost of the damage, and so we're going to set the carbon price in accordance with that cost. Thank you.
Thank you, Professor. Our next question. Do LDCs have any reason to be worried about the use of carbon border adjustment regime?
I think so. I think that less developed countries, least developed countries have contributed less than wealthy countries to the existing stock of carbon, to the existing problem of global warming. And because they're less developed, imposing more costs on them will slow their development. So I think as recognized in the Paris Agreement and in the concept of common but differentiated responsibilities, least developed countries should have a smaller carbon reduction obligation than wealthier countries. And so one worry is that those least developed countries are subjected to an equal cost. Now, as I've said, it's important from a global public policy standpoint that there be an equal cost, but that's the role of carbon finance, to reimburse the least developed countries for their cost, to have them pay the cost of carbon, but get an equivalent amount for general use, so that they experience and change their behavior with respect to carbon, but are not paying the costs of that carbon reduction themselves. And so I think from the standpoint of least developed countries, there's a risk that they're not granted full common but differentiated responsibility, full special and differential treatment, to use the trade law jargon, in connection with this. So it's a complex problem, as I've pointed out, to find a way that includes carbon finance to establish what we need, which is a global uniform carbon price, without making it costly for least developed countries and developing countries. And that will require a great deal of negotiation.
Thank you very much. We just have one last question. And we're almost we've reached the time to end this, unfortunately, but we just have one more question. If that's okay, Professor. With the somewhat checkered process of S&D treatment in the GATT and WTO, do you think that the carbon border adjustment regime would work for the LDCs?
Yes, well, here I probably should have distinguished more clearly between common but differentiated responsibilities in the Paris Agreement and special and differential treatment at the WTO. I don't think that special and differential treatment has been so very beneficial in the trade system for developing countries. I think for generalized system of preferences systems, they've resulted in graduation just when developing countries are becoming competitive. Sometimes they've caused developing countries to misallocate their resources in certain products where they're not actually competitive because they have a tariff advantage. So special and differential treatment definitely has, as the questioner suggests, a checkered past, but it's not necessarily beneficial to developing countries either. As I said in response to the prior question, the concept of common but differentiated responsibilities is a much more defensible, economically justifiable and morally justifiable idea than special and differential treatment. Special and differential treatment doesn't necessarily make poor people wealthier, whereas common but differentiated responsibilities can do that. So, so I think that but the core of the questioner's question is valid, that I think this is a messy concept for the WTO. It's unclear to what extent common but differentiated responsibilities will be respected under Article 20 of GATT. And so we have a serious question to what extent the WTO system will permit national unilateral action by wealthy countries like the European Union that discriminates in favor of developing or least developed countries. Even though we might all agree that that's a good idea, it may be technically not permissible under WTO law. And so the questioner has an important point.
Professor Trachtman, thank you very, very much for your talk and for entertaining all the questions that came by. It was an absolute pleasure having you here, and we certainly look forward for more of your talks in some related or unrelated topics at North University. Thank you very, very much, Professor. For those of you who've actually missed any part of our lecture, please do realize that we will be having a recording of this particular session in our YouTube channel. Professor, thank you very, very much once again.
Thank you very much. My pleasure. Bye-bye.